What's up, everybody? Welcome back to another episode of The Lawyer You Know. Today, we're going to look at the Commonwealth's opposition to Karen Read's motion to dismiss. How did they explain themselves? Do they agree or admit that these are actual discovery violations? Do they throw anybody under the bus? How do they plan on curing any of the problems that they think they may or may not have caused? Plus, we're going to take a look at a motion to amend the scheduling order, which gives us new details of guess what's coming, even more of the same. And we may even look at some clips of the prior trial to try and get better context about the whole Brian Higgins situation. But I think there's more going on there than just one clip would possibly show. But we're going to get to all that and more. Make sure you guys hit the like button. Let's get to it. All right, so we are going to start out with the Commonwealth's opposition to the motion to dismiss. And if you remember, the motion to dismiss was solely focused on government misconduct, basically withholding, destroying, changing, editing evidence to make it in a way that is violating to Karen Read and her right to a fair trial. So there's a number of different ways the Commonwealth can go about responding to this. The way that they decided to do it was basically an overall view and to say maybe mistakes were made, but we're going to blame other people, not us. And we're going to say at the end, it really just wasn't prejudicial enough to matter. That's what they're saying. And I will say, for maybe the first time since Hank Brennan has been on the case, I found myself thinking there is absolutely no way he can possibly agree with what he is saying in this motion. He's a criminal defense attorney. And I have felt like most of the arguments, if you agree with them, if you disagree with them, you think he's lying, whatever, most of the arguments, I felt like he was arguing like a lawyer. You can see the lawyer arguing both sides of these things. But the admissions he makes in this response, and then the arguments that follow, to me, I just kept thinking, there is absolutely no way you actually agree with what you're saying here. I really find it hard to believe. I would love to talk to him about it. Obviously, I know he's not going to talk to me or anybody about this case at this point, as he shouldn't. But I would just really love to talk to him about this and be like, you really believe this? What you said right here? This is the tough part of it for me for this motion. So here we go. Now comes the Commonwealth in the above captioned matter and submits the following in opposition to the defendant's renewed claims that her indictments should be dismissed because of egregious governmental misconduct. The Commonwealth disputes any ethical violations or misconduct, let alone misconduct that taints the legal system or infringes upon the defendant's right to a fair trial. Therefore, the defendant's motion should be denied. Dismissal as a sanction is a very strong medicine, and it should be prescribed only when the government misconduct is so intentional and so egregious and appropriate only upon a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. I do agree with him that it needs to be the worst of the worst. This is the highest and harshest remedy for any kind of misconduct. To the extent the defendant has suggested that egregious circumstances might warrant dismissal, the Supreme Judicial Court has noted that we have never dismissed charges in such circumstances in the absence of prejudice. So it's not just that something went wrong, you actually have to be prejudiced. And by the way, just because this happened in Baldwin case, every jurisdiction, every state is different. Every Supreme Court of the state is different. The higher courts, the appellate courts. So it's not apples to apples always. So just because some people may say this is worse than Baldwin doesn't mean it's automatically going to get dismissed in this jurisdiction. Judicial responses should be limited to truly remedial and not punitive measures. I will say, as I read this very first paragraph the very first time, I started thinking to myself, he knows. He knows that there are problems. He knows that things went wrong. He knows that this is not how it's supposed to go. And that's why he has to argue the lack of sufficient prejudice in order to win at the bottom line. Because he knows that this is not how a case is supposed to go. This is not how an investigation is supposed to go. And this is definitely not how discovery is supposed to go on the part of the state or the Commonwealth, the prosecuting body in a criminal case. The Commonwealth does not dispute its prosecutorial obligations and constitutional duty to disclose in a timely manner material exculpatory evidence over which it has possession, custody, or control. And that's important. Over which it has possession, but not just possession. Sometimes prosecutors get confused and they start arguing, we did not possess this and therefore we didn't have to turn it over, but it's not. It's possession, custody, or control. Nor does the Commonwealth dispute its broad obligations to inquire and disclose any facts that would tend to exculpate the defendant or diminish her culpability, and all statements of witnesses. However, to prevail on a claim that the prosecution failed to disclose exculpatory evidence, the defendant must first prove the evidence was, in fact, exculpatory. Exculpatory evidence includes all evidence that tends to negate. So it's not that it proves your innocence. Okay. And these are the important aspects and details that we have to talk about. It doesn't have to be a video of somebody else committing the crime to be exculpatory. It tends to negate the guilt of the defendant or provides some significant aid to the defendant's case. Now, these are kind of vague, these are kind of broad, but this is what we have to go with. And while rightfully broad, the conception of exculpatory evidence is not boundless. So that's not exactly a tightening up. It's like, well, it's broad. It's not boundless. Like, it's not anything, but it is pretty broad. And most jurisdictions, most case law, most judges view it that way. Canton PD surveillance video. Let's start there. In 2022, the Commonwealth provided the defense with approximately 90 crime scene service photographs depicting the condition of the defendant's vehicle in the Canton Police Department Sallyport. Further provided to the defense was the ring surveillance video of the defendant's broken rear right taillight at approximately 5 a.m., statements of witnesses who observed the defendant's broken taillight around 5:30, Canton Police Cruiser video depicting the defendant's broken taillight approximately 8 a.m., observations of damaged taillights by the Dighton Police, and automated vehicle location data from troopers cruisers who were assigned to the CERT team, evidencing that the CERT team was on Fairview Road before the defendant's vehicle arrived at Canton Police Station. Lieutenant Kevin O'Hara of the Mass State Police CERT team testified, and his automated vehicle locator records confirm his arrival at 34 Fairview at 4:56 p.m. on January 29th. O'Hara additionally testified his arrival was preceded by one other trooper from his unit, Trooper Jason B. At 4:54. The defendant's vehicle arrived on the back of a flatbed truck to Canton PD at 5:30 p.m. Defendant also has repeatedly represented in the media and postured at trial that her taillight was broken at 5 a.m. by striking the victim's parked vehicle in the driveway of the victim's home. The Commonwealth has provided substantial evidence, including accident reconstruction video from its expert, Judd Welcher, demonstrating otherwise. Based upon beyond unsupported claims and vague innuendos, the defense struggles to establish how the condition of the defendant's broken taillight in the Canton Police Department Sallyport is in fact exculpatory or the most crucial and highly contested issue in the case. He's basically proving the defendant's point by saying, here are all the ways that we prove the taillight was broken. The defense thinks they have all these ways to prove it wasn't broken or it was just cracked or broken a different way. And he's saying, clearly we're right, therefore it's not a highly contested issue. But in fact, that's exactly what he's doing, is contesting the issue. Number one. Number two, you don't get to prove what is important to the defense. The defense absolutely argued this taillight as a huge deal, and their accident reconstructions, all based around the fact that the way this taillight was broken could not equal hitting John O'Keefe. The injuries on John O'Keefe are not consistent. It's absolutely a big part of the case. For him to act like it's not is crazy. I don't even know why he would make that argument. Then he stacks all the evidence they did give about the broken taillight. And so much of it is somebody's testimony, law enforcement's testimony. And I'm sorry, but in certain cases, that's just not good enough. And if video evidence contemporaneously recorded exists, that is by definition the best evidence of the condition of something. Because when an individual is talking about their observations, when an individual is taking pictures, the individual has control over the situation. Does that mean they did something wrong? No. And if there was no video, that would be allowed into evidence. It's totally proper for that to be allowed into evidence. Somebody testifying about what they saw, a picture taken contemporaneously that somebody can testify to, this is the true and accurate representation of what I saw. That is absolutely evidence, and it should be allowed in as evidence. But if there's a video, that's better evidence, especially unobstructed, unedited video. The defendant's motion at 7, as he was just citing. Despite claims to the contrary, the defense never filed the motion to preserve or in its perpetually evolving theory of a case, did the defendant specifically request prior to November of 2024 surveillance video from the Canton police station? So this is another rich statement. And this is something that does come a little bit down to judicial discretion. Are the broad and vague requests from the defense specific enough to request video? I would say yes. And number two, in the way that they did in getting more specific, should that be held against them? And to me, the reason this comment is rich is because he's blaming the defense for not knowing something. Yet, later in this motion, Hank Brennan says the prosecutors were even unaware of this video at Sallyport. So if the prosecutors who work with law enforcement, and I assume talked about this investigation and the evidence they had, and I assume asked how we can prove X, Y, and Z, and if we get to the Higgins clip, he even baits the defense. There should be video of it, of him at Canton PD, which there wasn't of the at least full version of it. If the prosecutors didn't even know this video exists, how is the defense supposed to know the video exists? They made this request, in my opinion. They made it. It should have been fulfilled. They should have been given the video, and they weren't. Let's read this footnote. The defense claims their February 2nd request for all physical evidence, including anything present on or near the decedent at the time of his body was discovered. Anything found at the alleged crime scene was sufficient notice to the Commonwealth to preserve footage from the Canton Police Department Sallyport, where the defendant vehicle was stored for approximately 2 days. Defendant Exhibit A. The Canton Police Department is not the alleged crime scene. The Commonwealth could not reasonably have anticipated the defense ever evolving third-party culprit claims, nor to this day made the Canton Police Department video pertinent to their amorphous and fluid claims. It is the weapon, right? The car is the weapon used. And if you have it in its condition, showing up and leaving, and anybody doing any work to it or touching it, and the request for any photographic or other physical evidence, to me, that is broad enough. Why do you have cameras in there? Nevertheless, the trial prosecutor was not aware of the existence of the surveillance video in the Canton Police Department Sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor. So I haven't read this transcript, obviously. And when it comes to Michael Proctor, who is Michael Proctor? Well, he is the lead case agent, the lead officer, the lead detective, whatever he is, lead investigator on the case, interviewing witnesses, gathering evidence, handling everything in this case. So the grand jury testimony brings out that Proctor knew that this video existed, and he told federal prosecutors at the grand jury proceedings, but he never told the state prosecutor who he's working closely with on this case. Did the state prosecutor ever ask? We're going to hear cases cited where reasonable inquiry is a must for the prosecutor when it comes to discovery. And Trooper Michael Proctor, as the lead investigator on the case, is absolutely an agent of the prosecutor. If something is in his custody or control, it is also in the custody or control of the prosecution team. In a lot of cases, if you're not Michael Proctor and you don't have the background of Michael Proctor and the text message of Michael Proctor, the lead investigator would sit right next to the prosecutor. Francois, Peter, you're so pro Karen, but I still like you. Here's the point. Not a single bit of this has to do with Karen Reed so far. If I'm being honest, this could be John Smith. This could be Peter Tragos. This could be Brian Koberger. This could be R. Kelly. This could be P. Diddy. I don't care if it's Karen Reed or anybody else. I would feel the same exact way about these arguments. The knowledge about the Sallyport videos, the source was Trooper Michael Proctor. That is the prosecution team. So to act like you didn't know it existed, and Higgins, I don't know what Proctor said at the grand jury proceeding, but we know that Higgins, in his testimony, said there's a video of it, so Higgins knew there was a video. So all these cops want to try to say the video exists to try and bolster their credibility. Yet they won't just give it to the defense to see what actually happened. And that's my problem. I don't care who the defendant is. Cops can't use video as a sword and a shield. There's video of it. So a juror listening would be like, oh, okay, well, he's obviously not lying if he knows there's a video camera there. That's using it as a sword. And then saying, well, you can't prove the condition of her taillight. Video doesn't exist. We purged it. It's blurry. It skips. That's using it as a shield against potentially bad evidence. That's what I don't like. That's really what I don't like. And I appreciate you being here as well. If you're not pro Karen Reed or you think she's guilty, I appreciate you being here. I appreciate you commenting. I did not mean to roast you with that. Nobody go after Francois at all. I want those comments. I want those questions. I thought it was a good question, and I appreciated the context we're able to give here with those types of questions. All right, let me see where I was. Promptly, on April 4th, 2024, the Commonwealth provided the defendant with 9 surveillance videos in its possession, consisting of video footage of the main driveway of the Canton Police Station and video files, et cetera, et cetera. So again, Proctor says the video exists, and what does the Commonwealth do promptly? They provide clips. Why are they clips? Have we ever gotten to the answer why, when they were able to go look back, the whole thing didn't exist? Or who clipped it up and who decided which clips to keep? That's what I don't get. Notably, the quality of the video is poor in certain portions. However, that is the condition it was recorded in and the condition in which it was received by the prosecutor. So he's like, yeah, we agree. Some of it's grainy. Some of it's blurry, but that's the condition we got it in. So sorry. And again, this is when it comes down to the prosecutor just telling the judge, hey, this is what we got. This is when we got it. Sorry. The Commonwealth has produced evidence that since January of 22, the Sallyport camera was replaced due to its defective condition and during the first trial. The Commonwealth called the technology director for the town of Canton to testify about surveillance video systems throughout the town, and he was subject to cross-examination by the defense. I got to be honest. I've had cases, premises cases, where they have all these cameras up, none of them work, present a false sense of security, check boxes for their insurance for them to pay a cheaper premium, and then they replace them after our client dies there or gets seriously injured there, and that's just not good enough. And that's a civil case. The Commonwealth filed its certificate of compliance on April 10, 24, noting that, to the best of its knowledge and after reasonable inquiry, it had disclosed all information subject to their rule, Rule 14. So once again, the Commonwealth filed their certificate of compliance. But what does that actually mean? If the certificate of compliance means nothing in litigation, then the rules don't matter, and we might as well not have rules. If the other side tells me, here's all the discovery, I have to be able to stand and say, this is all the discovery. If I can't, what's the point of the deadline? And that's what happened here. Here's all the discovery to the best of our ability, and then more discovery pops up. When that happens, you better have a good reason for it. I'm not saying it's impossible. Nobody's perfect. It happens in cases all the time. But why and how did we get here? And it definitely shouldn't be happening a year later. Yet that's what's happening in this case. That's what's so mind-boggling. The parties were in court on Friday, April 12, 24 to argue motions in limine. During the defense's televised motion to admit third-party culprit evidence, Attorney Yannetti made representations about the Canton PD surveillance videos. Following the hearing on April 17th, Brian Tully sent prosecution team members an email stating, I spoke with Chief Rafferty. She reviewed the video of the SUV arriving at CPD exists, and we should have it contrary to what the defense represented on Friday. And that's the other thing. It's like, right when the defense says something doesn't exist, it's like, you liar, we do have it. Here it is. It's like, well, you said you gave us everything. That's the problem. Alpha Fox Adam, lawyer, how do you interpret the continuing discovery duty? So it is actually different in different cases, different in federal court. We always supplement as a duty, just as a matter of principle. We always supplement. When we get something new, we turn it over. We just want the case to resolve the way it should resolve, right? That makes life easy. If it's a civil case and it's a really huge multi-million-dollar case, we want it to settle for multi-million dollars. If it's a $50,000 case, we want it to settle for $50,000. You provide the documentation that proves whatever the case is, it is. In a prosecution case, you provide everything. If he's not guilty or she's not guilty or you can't prove it, they should be, charges should be dismissed. If they're guilty, they should plead to it. Take a plea deal, go do your time if you did the crime, right? John O'Rourke, funds for lighting up the pickleball court. I have so many memories growing up playing sports late into the night with family and friends on our sport court. You know, that's a great point. I didn't even think about the fact that, like, as my kids get a little older and their friends are coming over playing basketball, pickleball, this is more to do with the members only live where we toured the pickleball court. He just lost me. The defense is relying on the taillight. Yeah, that's why you just can't go full idiot, right? I wish I didn't say that. That's why you can't go so far out into things that are illogical. I did not mean that. I do not think he is. And I retract that statement for anybody that clips it. It is what it is, but that is not what I meant to say. I was trying to not use a line from a movie that was offensive, that was a funny movie, and then I ended up there. So this is what happens when you talk too much on YouTube. Too many hours here. All right, let's get back into it. The video depicts the vehicle entering the Sallyport and crime scene tape being put up. She is putting it on a thumb drive for us in the event that we don't have it. The prosecutor had not previously received this video or knew of its existence. Isn't that convenient, right? The prosecutor doesn't even know about something until they turn it over so that they can protect themselves. You cannot bury your head in the sand as a prosecutor, this prosecutor or any prosecutor, in order to not turn things over to the defense. That's why the way case law develops from lawyers, the way rules and statutes are written for lawyers, is we base it on stuff that happened in other cases. And so the way we get to the point of the cops and law enforcement are considered prosecutors' agents, and if they know something exists and have access to something, that is considered the prosecutor knowing it as well, is because this exact scenario happened in the past, and the courts were like, that's not fair. That's not just. We have to fix that. We have to fix that. We can't let a wall be created between law enforcement and prosecutors just so that prosecutors can go say, I didn't know about this. I see everybody got the movie Simple Jack. DUI guy, what's up? Isn't it so bad we can't speak the truth? I feel like I can speak the truth. I don't ever feel like I can't speak the truth. I try not to be a jerk, right? That's it. Sometimes I say things that are, like, I just think that was a bridge too far. I think that was a jerky thing to do. It was mean. It was disrespectful. I didn't mean it that way. I don't think this is a good argument. I don't think it's a smart argument. I don't think he's an idiot, period. That's the truth. And that is the truth. And I feel like I can speak the truth, Nightclubs. New motion today. Brendan found more footage from Sallyport plus found activity logs from Sallyport will give to the defense Monday. Yes, we are going to read that motion. Ashley, thank you for sending me these, by the way. Ashley sent me these. Shouldn't the defense be able to question all of these people under oath and work backwards to figure out how all these videos are appearing? Yes, absolutely. I think that'd be great. Again, takes time and money and annoyance when people are just trying to block you left and right. When, yes, all of the information should push us towards justice and truth for John O'Keefe. All right. Prosecutor didn't have it. Shocker. Subsequently, the prosecutor requested that both Massachusetts State Police, CAM PD, produce all relevant and material surveillance video. Isn't that nice that they did it 2 years later? The Commonwealth provided the defense with surveillance video entitled Interior Sallyport Back Wall. Notably, what was produced to the Commonwealth and provided the defense was inverted surveillance footage due to the camera settings. I'd like to understand that. The Commonwealth did not manipulate or alter any video and entered as a trial exhibit the video in the condition it was received, contrary to the defendant's misrepresentations that the Commonwealth's intention was to mislead or deceive the jury by introducing the inverted video. The defendant fails to mention that after the defense altered the evidence to correct the image to appear consistent with the human eye, the Commonwealth played the entirety of the video that was corrected, yet altered video, which reveals that Trooper Proctor is standing feet away from the defendant's vehicle, never touched the right rear taillight. Furthermore, omitted from the defendant's filing is that the fact that Trooper Proctor's DNA was not on the right rear taillight. It's like, okay, like there's lots of ways that could happen. Here's my point. He could be telling the absolute truth, but it's a he said at this point. And that's why That shows you the importance of the video, a clear video, an uncut video, an uninverted video. And by the way, he's basically saying it's so unfair the defense is no longer giving the Commonwealth the benefit of the doubt. It's like, you've already stated you're not going to give the defense the benefit of the doubt. And I can kind of see it from both sides. This case is highly contentious. It's highly public. So neither side is giving each other the benefit of the doubt. And that's why these types of statements are going to come from both sides. After the trial, a certified forensic video technician employed by the Norfolk District Attorney's Office reviewed the surveillance footage that had been previously produced to the defense, recognizing that the video was extremely dark with minimal visible detail. The video technician clarified the video footage on October 10th, 24. The Commonwealth produced to the defense clarified videos, reports detailing the forensic clarification process, associated hash values, and extracted still images from the Canton Police Sallyport. Furthermore, the video technician clarified video images from the Canton Police cruiser camera footage on January 29th, Canton Police Department Interior Sallyport front wall footage from January 29th, and the Mass PD crime scene services section photographs from February 1st, each depicting the same damage to the right rear taillight, and encapsulated those images in a substantive report provided to the defense. I do agree. There's plenty of evidence, pictures, and testimony about that taillight, but none of it provided clarity for either side. I think D has to hammer to the jury too many screw-ups and weird activities to have no reasonable doubt, and they cannot convict with that doubt. Yeah, I agree. All of this goes towards it. Susie, it is hard for me to understand how this trial can continue with so much reasonable doubt. If the second trial is declared a mistrial again, would the Commonwealth retry the case a third time? It feels like the answer to that question is yes. It feels like that's where it would be heading. Romy, I don't care if you're pro CEW or pro defense. If you live in MA as I do, these issues should concern you. I would never want these kinds of investigations and discovery issues to happen to any defendant. I agree. No matter where you are, right? No matter where you are. Liza, Tropic Thunder has ruined us. The movie is so inappropriately funny. I can't help myself. I love it. It's so funny. B&B, we love you, Peter. No need to apologize. Please don't ever change. That movie is hilarious. It wasn't too much. You guys are the best. You guys are the best. Okay, let's get back to it here. After trial, on August 21st, 24, the Canton PD provided the Commonwealth with 2 additional videos. Video from the interior Sallyport camera on January 1st depicting the camera captured all video in an inverted fashion to rebut the defense's suggestion that the video had been tampered with and consistent with witnesses' trial testimony. Video from the interior hallway and exterior of the Canton Police Station that shows Brian Higgins at the Canton Police Station during the early hours of January 29th and depicts Mr. Higgins moving his law enforcement vehicles due to the snowstorm. It's like, why was this Higgins video not turned over in the middle of trial when the inverted video was? How was it found differently? Like, explain that to me. Dumb it down for me and explain it to me. Because I know law enforcement does complicated things for complicated reasons. I don't get that. These videos were provided to the defense on October 10th, 24, along with a letter from Canton PD noting their August 21st, 2024 production. Prior to their production, the prosecutor was unaware of the existence of these videos. The defense boldly claims that the surveillance video of Brian Higgins in and outside the Canton PD proves that he perjured himself before a federal grand jury. Again, I don't know specifically what his federal grand jury testimony was. That claim is extremely prejudicial and false. In support of this claim, the defense cites federal grand jury transcript. Further, the defense is unable to demonstrate any prejudice. It's like, any prejudice? These are the people they're pointing the finger at. Did they do it? I don't know. But the worse you can make those people look, the more lies you can stack, the more inconsistencies you can stack, clearly that's better for the defense. That is almost the definition of exculpatory evidence. Both Brian Higgins and Brian Albert were thoroughly cross-examined at trial about their phone calls with one another. Yeah, but nobody ever brought up this phone call outside Sallyport that I can remember. You guys correct me if I'm wrong. I listened to some of the Brian Higgins testimony again. I don't remember a 134 call. I could be completely wrong, though. Was it not in his phone logs? I can't remember. I'm getting it all kind of confused and mixed up at this point. The Commonwealth provided the defense 167 pages of access card swipes records throughout the Canton PD on January 29th. Mr. Higgins was cross-examined about his movements through the Canton Police Department on January 29th. All right, let's take a pause here for a second. Let's bring up, I'm just going to play a couple quick clips of Higgins' testimony, and I'm going to play it sped up. So I apologize for people that don't like that. But I'm going to play this just so we can kind of hear some of the back and forth. There was more to it. I'm not trying to pull clips out of context. And again, like I said, I have not read his grand jury testimony. So let's just take a listen to a couple clips here real quick.
Right by that flagpole, correct?
If I did,
I
would have done something to help him.
I asked you if you saw one.
No, I did not.
And that's because there was no body there, correct?
I didn't see anything.
Because if there was a body there, you certainly would have seen that.
Objection.
Where exactly did you go when you left 34th Fairview?
I went back to the Canton police station.
When you were asked that on direct examination, you said you weren't sure where you went when you left 34th Fairview, either home or Canton PD.
No, that's not what I testified to.
Did something jog your memory about where you went?
That is not what I testified to. That was in relation to where did I go after I left 34th Fairview the next morning.
Why did you go to Canton Police Department that morning?
What's the question?
Why did you go to the Canton Police Department that morning?
The morning when I left 34th Fairview, the Friday into Saturday?
Correct.
To move 2 vehicles.
There's been quite an evolution of that story over the years, has there not?
I don't understand the question.
All right, let's talk about that for a second. You had an initial interview with Massachusetts State Police on February 3rd, 2022.
Yes.
Correct? And you indicated during the course of that interview, which was just a couple of days, 5 days after the events in question, that you left Brian Albert's house, went to Canton PD to, quote, fulfill some administrative obligations, end quote, correct? You later said, when you testified in front of the grand jury on April 28th, that you went to Canton PD to do, quote, administrative work, correct?
Yes.
You never mentioned.
I said administrative things.
You said administrative work was your testimony in your transcript.
I believe it was things, but okay.
Okay. Can we agree, Mr. Higgins, that you didn't mention anything about moving cars around, correct?
Well, that would be administrative.
So when you say I went to Canton PD to do administrative work or administrative obligations, you meant moving your car, your personal vehicle?
Yes.
Okay. Although you didn't say that you were going there to move your personal vehicle, right?
No, I said I didn't move my personal vehicle. I moved work vehicles.
Or either one. You just traded off vehicles, moved them out of the way, right?
I moved the purpose for going back there was to move 2 work vehicles.
And the reality is you had gotten Canton PD earlier in the afternoon and actually moved some other vehicles, traded vehicles, didn't you?
I swapped vehicles out. That's correct.
Right. And you left the vehicles that you now claim you had to go move exactly where they were, even though you knew a blizzard was coming, correct?
That is correct, yes.
So you didn't move the cars a few hours earlier, knowing that you just have to come back and move those cars a few hours later. Right?
I was more concerned to go eat and have a drink because it had been a long day.
So wouldn't you want to move those cars early on so you wouldn't have to go all the way back to Canton and play parking lot with these cars in the middle of the night?
Not really.
Mr. Higgins, you weren't actually at Canton PD to do administrative work at 1:30 in the morning, were you?
I was moving the vehicles. I'm sure it's on video.
And we'll talk about the video in just a second.
So that's where he throws in, I'm sure it's on video. Like, again, that's using it as a sword. That's saying, I am right and I can prove it to the jury because the jury never saw that video that I'm aware of. And it's like, you knew there was a video, right? So how did the prosecutors not know there was a video? And I get it. We don't need to get into how illogical it is, why he went back, when he went back to move videos, but I don't remember anything about a phone call there. And we're going to jump ahead a little bit to when they actually talk about some of these phone calls between him and Albert. And I know there's like a 2:20 a.m. phone call that they talk about. These are the butt dials and stuff like that. I'm just going to play it because never did anybody mention a 1:34 a.m. phone call. Alan Jackson didn't. I think this is evidence that if Jackson knew about a 1:34 phone call or saw a video, he would have asked Brian Higgins about it because he asked him so many questions about these phone calls at 2:20.
And you were thereafter confronted with those phone records, correct?
I was asked about them, yes.
And those phone records established that you and Brian Albert actually exchanged not one, but 2 phone calls at 2:22 a.m. that morning at a time when you claimed you were in bed asleep, correct?
I have no recollection of any phone calls.
I have no recollection of any phone calls. Now, again, is that just does he just mean between him and Brian Albert? Does he mean that all that night? I don't know. I don't understand if there was a 1:34 phone call, why wasn't it on the phone report that Jackson had? And if it was on the report, why didn't he ask about it? I don't know the answers to those questions, but it's just very strange.
May I approach you on?
Yes.
They go through, we're going to watch a little bit more of this.
With QQ and one with 17, when I'm referencing them.
Okay.
Take a look at the one that's marked with the QQ.
I see it.
You've certainly seen that document before, correct?
I think I've seen it maybe on a screen, not in my hand.
That was a These were the records that were shown to you at a prior hearing.
Yes,
And you acknowledge that at least the one marked QQ is a record of your calls, correct?
it has my name, my telephone number, correct?
And it indicates that on January 29, 2022, at 2:22 and 35 seconds, you received a call from Brian Albert, duration of 1 second, correct?
Yes,
In other words, Brian Albert called you at 2:22 and 35 seconds, but it looks like you missed the call, correct?
I see the 1 second call, yes.
There's a second call just below that on the same date at 2:22 and 52 seconds from you to Brian Albert. Do you see that one?
Yes,
And the duration of that call is 22 seconds, correct?
I see that, yes.
So 17 seconds after you missed a call, according to these records, from Brian Albert, you called him back, and there was a call lasting 22 seconds. Is that right?
That's what the records say.
May I approach?
Yes.
And this is when he kind of gets into that they're butt dials, and Ashley saying he wasn't given all the phone records. And another Ashley said the same thing. Yeah, but he had obviously phone call logs. I guess I didn't realize that he had partial call log. It's hard for me to, without looking at the documents myself, it's hard for me to remember exactly what they did have and didn't, because he questions him about specific calls on a call log. He's showing Higgins the call log, but yet it's an incomplete call log. Or did he have a bro phone and a work phone? I don't know. Let me see if there's any. That was pretty much the gist of what I wanted to talk about with that. Let's get back to the motion. But not great, right? And exculpatory, in my opinion. Nina said, your thoughts on the decision from the judge that no metadata is needed. Videos could be AI generated. I don't know. Again, I'm not the biggest tech guy in the world. Always turn over the metadata. Just turn it over. If it shows nothing, fine. If it shows something, explain to the jury what it shows. If it's so confusing and makes no sense, the jury's just going to go over the jury's head and go over my head. I don't understand what the fear is of providing that information. That's the stuff that is annoying to me. All right. On January 28th, the Commonwealth provided the defense with surveillance video from the main driveway side exterior Sallyport that depicts a different camera angle of the defendant's vehicle arriving at the Canton Police Station Sallyport. Notably, consistent with other videos received from the Canton Police Station Sallyport, the quality of the video is poor. There is absolutely nothing depicted in this video that is exculpatory or undermines the consistent evidence that the defendant's right rear taillight was broken and pieces were missing prior to the vehicle being towed from Dighton. Prior to January of 2025, the prosecutors had never seen this video. I believe him that they'd never seen it, but that's not enough. Just because you've never seen it doesn't mean you didn't have a duty to turn it over. And that may sound illogical, but that's like me saying, I don't know what's in the trunk of my car. Could be a body, but I'll never know. It's like, no, go look in the trunk of your car if they're looking for a body near your house. It's like, you can't just say you don't know something exists because you didn't go looking for it. You have a duty, which is why you have to say stuff in your certificate of compliance that after due diligence, after I tried to look, after reasonable inquiry, this is all we have. And it's not too far-fetched for you to ask Michael Proctor or Higgins if video exists. That's not too far of a stretch. That's not unduly burdensome for you. After directing a review of all physical and data files, the video is located within a paper case file of investigators. After directing a review of all physical and data files, this video was located within a paper case file of investigators. I don't know what that means. I've prosecuted cases. I've defended cases criminally. I've handled civil cases on both sides. I have no idea what this means. That somebody pulled the video from a computer, put it on a disk, and then put it in a paper case file of investigators? Would that not be a file you would look at as the lead prosecutor on a case or the lead investigator on a case and maybe bring it to the prosecutor's attention? This is within the custody and control of the prosecutor. After inquiry, it was learned that an investigator obtained this video from a Canton Police Department in 2022. How? How did he get that video? And it was placed in a physical case file and never provided to the prosecutor or multimedia assistant for download. This right here, to me, sounds like police misconduct. Now, you can say it's negligence, and that's fine. I would call it recklessness at best. That you're downloading photos and creating hard paper files of evidence for a murder case that is being litigated, and you don't give it to the prosecutor. Again, it does not matter what the title of this video is. If it would have been Karen Reed, Brian Koberger, P. Diddy, it does not matter. If this is what cops are doing, that's a problem. So this is Hank Brennan throwing the police department under the bus. This alone is enough, in my opinion, for a judge to look at a case and be like, you blew it. We have had criminal cases in federal court dismissed and thrown out after a first trial, actually, after we lost a first trial and won an appeal for less than this. They did some testing on a phone. We wanted to retest it, but they destroyed it after the first trial. So we weren't able to retest it. And they were ordered to preserve it for the second trial. That's part of what happened. Although the process, and this is after it had already been tested and they had it for the first trial and everything like that, because it's so important. Although the prosecutor was wholly unaware of this video until recently, the Commonwealth does not dispute that the video was in its custody. So that's an admission that videos like this, that law enforcement knows about, has control over, has custody of, is also in the custody of the Commonwealth. Had the prosecutor known about this video, it would have been produced as every other video known to the prosecutor was. But that is not the standard, and that is not good enough. That is not good enough. Only providing what you know about, as crazy as that sounds, is not good enough. You've got to go ask questions to everybody because you might not know everything. Even in circumstances where the prosecutor fails to disclose evidence a defendant is entitled to receive, there must be a showing of irremediable harm to the defendant. So this is where they admit we failed, we violated discovery, we violated the defendant's rights. It just wasn't bad enough. So from my perspective, just like he admitted over and over again in the ARCA motions, that he's not even trying to strike ARCA anymore. So there's no reason to even consider striking the ARCA witnesses. Here, we don't even have to argue if there was violations. Now, was it intentional misconduct or reckless or negligent? Sure, we can argue about that, but there were violations of her discovery rights and her right to a fair trial. In measuring prejudice, this court must examine to the extent of which the defendant was disadvantaged in defending herself when considering the prejudicial quality of exculpatory material evidence. In measuring prejudice, it is the consequence of the delay that matter, not the likely impact of the non-disclosed evidence. And we ask whether the prosecution's disclosure was sufficiently timely to allow the defendant to make effective use of this evidence in preparing and presenting this case. For the second trial, I would agree with them. It probably is timely. But they were so close to winning the first trial. They were so close, closer than most criminal defendants get at the end of a trial, especially with this series of crimes. The defendant cannot show irremediable harm to her right to a fair trial as it relates to the Canton PD surveillance video. While the January 28th, 25 production was untimely, the poor quality of the videos makes it difficult for either party to benefit from. So once again, the low quality evidence prevented is just good for the Commonwealth because we can't really see what's on there, and it's not prejudicial because the defense wouldn't have really been able to use it anyways because the quality is so bad. While the January 28th, furthermore, this video depicts the same event that was contained on the surveillance videos produced on April 4th and April 23rd, simply just from a different camera angle. Further, while the Commonwealth would argue that the videos from the Canton PD Sally Port are inculpatory, the defendant benefited during the first trial by suggesting, without any substantive evidence, that the poor quality of the video and or gaps in time due to the improperly functioning camera system were caused by an improper police investigation and systemic police misconduct. I don't think this makes it any better. Because you got to call somebody to be like, this video existed from January of 22, right? And you didn't turn it over to us till January 25. And now the quality sucks. And now parts are missing. In November 24, the defense made an informal discovery request relative to Canton PD. The Commonwealth and Canton Police Department facilitated the request, and on December 12th, 24, in the presence of the defendant expert, it was discovered nearly 3 years after the incident that the footage of the DVR was overwritten. System no longer maintained the original surveillance footage. This has also marked the first time the defense had made any request for metadata or logs pertaining to these videos, as neither did the defense's February 2nd, I think it means 2022, not 2002, or October 5th, 22 motions or corresponding orders make any reference to such. A defendant who seeks relief from the loss or destruction of potentially exculpatory evidence has the initial burden to establish a reasonable possibility based on the concrete evidence rather than a fertile imagination that access to the lost or destroyed evidence would have produced evidence favorable to his cause. If he meets his initial burden and balancing test is employed to determine the appropriateness and extent of remedial action, the courts must weigh the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. Push that burden on the defendant any chance you get. And here, the defendant fails to meet the initial burden. She has presented absolutely no evidence that a forensic copy of the Sallyport surveillance video with the metadata logs would have been exculpatory. Rather, she relies upon innuendos and unsubstantiated allegations that are speculative at best and not the equivalent of concrete evidence. If this was the only thing in the case, I still think it may be enough to win some of these motions. But it's not the only thing in this case. And so it's not just rank speculation. It's really not at this point. And you know where I started in this case. And generally speaking, this is not where my mind goes. But when the police show this kind of misconduct and horrible investigation and just lack of consideration for the rules and processes and procedures of how things need to be done, you got to fix that. Even if this court were to engage in a balancing test, dismissal would be inappropriate as there is no evidence of egregious misconduct on the part of the Commonwealth, and any potential prejudice stemming from the overwritten videos could be remedied at trial. The court must consider the culpability of the Commonwealth, the materiality of the evidence, and the potential prejudice to the defendant. I agree with all of that. The defendant can point to no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video to fully disprove the defendant's repeated and baseless allegations of evidence tampering. Statement of Jennifer McCabe. In violation of the defendant's discovery order to produce all reciprocal discovery, including impeachment evidence to the Commonwealth prior to the start of trial, it was during the third week of trial on May 7th that the defense produced reciprocal discovery to the Commonwealth regarding location information of Jennifer McCabe's cell phone. 3 days later, which the Commonwealth should have already had that, on May 10th, in anticipation of her trial testimony, the Commonwealth met with Jennifer McCabe, as it does with all witnesses. On May 29th, Tully wrote a police report memorializing the meeting and explained, when asked why her cell phone would have been in the area of Lank's house, Jennifer stated she was with Carrie Roberts, who was picking up her daughter at the residence. Jennifer did not speak with Michael Lank while at the residence. The Commonwealth produced Tully's report on June 3rd. On June 18th, in response to the same claim raised by the defense, the prosecutor explained to the court that Ms. McCabe met with Tully, looked at some video, was asked a single question. That report wasn't available. I didn't have it until after Ms. McCabe testified, but it was given to the counsel prior to Lieutenant Tully testifying. Ain't that something? It's like it wasn't produced till after McCabe testified. Her witness prep, reports with her comments that were inconsistent at the very least. On May 21st, Jackson vigorously crossed Ms. McCabe, and she detailed her reasonings for being at Lank's house. During cross, Jackson elicited testimony that it was Tully who asked Ms. McCabe an open-ended question of, did you go to Lank's on the 30th? Jackson then questioned McCabe about whether there were any follow-up questions or whether the Commonwealth revealed the defense's report. McCabe testified neither occurred. Notably, the Commonwealth produced Lully's report. Once it was available to the defense prior to Lieutenant Tully's testimony. Tully was available on cross-examination about this recent meeting with McCabe and or perceived inadequacies in the investigation related to McCabe's phone's whereabouts. The defense declined to do so. So again, there's one thing about, yes, I actually agree with some of these points made by Brennan, that some of this was remedied. Jackson was given the chance to cross-examine these witnesses on what was found in the report, but that's not how a trial is supposed to go. This, again, on its own, this would never be enough. This right here would never be enough on its own. But as another thing to stack on top, it's just not right. It's not how a trial is supposed to go, and it might be the definition of trial by ambush. Furthermore, on May 22nd, 24, Roberts testified, Ms. McCabe had testified 1 day prior that she had accompanied Carrie Roberts to Sergeant Lank's driveway. The defense relinquished their opportunity to cross-examine Ms. Roberts about the event at Lank's house, let alone ask her, one of only few percipient witnesses, a single question. So, if you remember, there were a couple witnesses the defense didn't cross, and a lot of people were like, oh, wow, it's because they were so good for the defense, blah, blah, blah. Well, there are ways that can be held against you. You had the opportunity to cross-examine her, and you didn't. And that's exactly how the argument should be made if you're Brennan. But if you are a criminal defense attorney and you represent a criminal defendant, you are constantly making trial strategy decisions. And if you think a witness was good for you and you don't want to give the prosecutors the chance to go up and redirect and fix some of the mistakes, you don't cross. So because something brand new was brought up that affected their trial strategy to not cross this witness, now are they supposed to get up to help the prosecutor give them redirect by crossing on this thing that totally just dropped on them in the middle of trial? It's just not appropriate, and it's not how it should be done. I appreciate your kind spirit. Occasionally I'll ask my wife, how stupid do you think I am? And she'll shrug and walk away as to say, pretty stupid. Yeah, I get it. And that stuff doesn't bother me. Like, it is what it is. I try not to be a jerk as best I can. Marson, does his booty have fingers? Or were they using Nokias from the 2000s? Yeah, the butt dials. It's wild. Josh H. I think Brennan knows this case is going to get dismissed. He's just throwing crap at the wall to see if something sticks. I really don't think it's going to get dismissed. How come there are more videos? Why didn't they turn over the videos on the first trial? Wasn't this the same as the Baldwin case where the prosecution chose which evidence to turn over, right, Peter? It's also similar in the Baldwin case because they were like, oh, the wrong case file name was put on this, and this was put in something that we would never look at in this case. Kind of what Brennan said. This was put in a paper folder for investigators. It's like, so why didn't you look at it? Daniel, how is it possible that Proctor's disciplinary hearing still hasn't concluded? And how shady will it look to a jury if it's ongoing when the retrial starts? It's a great question, Daniel. You asking unanswerable questions, but I think at this point, Proctor is shot. Like, whether he loses his job, whether he's in the middle of it, whether they have the same information they have on the first trial, there's no way he's going to come out looking good. Can D-Team argue evidence of bad faith by Proctor? Sure. They have lots of potential evidence of bad faith in this case. All right. However, most enlightening on the defendant's lack of prejudice is that on June 18th, Jackson stated during the trial, they interviewed Jen McCabe, apparently had a full interview with her, totally took a report, dated the report. They held on to the report till after she testified. No, and it's like, well, it wasn't ready. The report wasn't ready. It's like, if you're going to do that prep and do a report, you should do it before she testifies. You control when the report is done. You control when the initial meeting is, and you control when she testifies. Yet once again, the prosecutors were like, oh, the report wasn't ready. Totally didn't have the report ready. BS. But the judge did try to remedy the situation by asking Jackson, do you want to call Jen McCabe back? And famously, we all remember, Jackson said, no, Your Honor, that's not my point. I've done the damage that needs to be done to Jennifer McCabe, and then he repeats himself. So once again, Brennan uses something like that against him. Call it showboating, call it whatever you want, playing to the cameras. He had the opportunity to cross McCabe, and he didn't. But again, that goes to defense trial strategy. Now you're looking like you're beating up on somebody who claims to be a victim of harassment. You're going to call her back. You're going to make her cry. You're going to be mean to her as a lawyer. You don't want to do that as a defense lawyer if you don't have to. It would have been much better if while you had her on the stand, one clean shot, give me all the information. I absolutely would have asked her about that. But now you've made it clunky. Now you're going to make me look like a jerk, like I called her up there multiple times. I don't want to do that. I've done the damage. And that's appropriate trial strategy. When given the opportunity to remedy any perceived prejudice, the defense declined to do so. Trial court security / juror dismissal. So this was interesting. This provided even more context on whatever the juror issue is. The defendants claim that a lieutenant of the Mass State Police was in charge of jury security is patently false. At no time did Lieutenant Fanning have contact with nor control or influence over the jury, nor was there jury tampering that deprived Ms. Reed of her constitutional right to a fair trial. So I think this was part of what was redacted. I don't remember reading that exactly. The defense's brazen misrepresentation previously proffered in media interviews in direct violation of the impoundment order of juror discussions and sidebars solely to mislead the public and jeopardize the integrity of the judicial proceeding are false and dishonest misrepresentations. No benefits of the doubt given. The executive branch of government is separate and distinct from the judiciary. The governance of the jury is solely within the power of the trial court and sworn court officers. The defendant's first trial raised significant safety concerns for both parties, members of the victims' families, witnesses, court staff, media, and the public. To effectuate both the defendant and Commonwealth's right to a fair trial, the court ordered a buffer zone around the courthouse. If you remember, Ron, the juror, said they could still hear stuff. To enforce the buffer zone and maintain order, approximately 50 uniformed officers from the Mass State Police and other local departments were deployed each day on foot, motorcycle, and bike in the area directly surrounding the courthouse. Additional law enforcement resources were available in proximity to the courthouse at the Dedham police station. As a superior officer assigned to the Norfolk District Attorney's Office Detective Unit and the only supervisor who was not a trial witness, Lieutenant Fanning was one of the commanding officers who was involved in the safety and peacekeeping efforts occurring outside the courthouse. Yet somehow the defense conflates the fact to misrepresent that Lieutenant Fanning therefore improperly influenced and tampered with the jury. To do so, the defense omits the remainder of the Assistant DA's McLaughlin statement to the court. ADA McLaughlin stated, and of course we have to miss that, however conveniently omitted from the defense's filing and extrajudicial statements is the following from ADA McLaughlin. At no time did Lieutenant Fanning enter the Norfolk County Superior Courthouse during the defendant's trial. Moreover, he never saw, let alone spoke to any member of the jury. Furthermore, there is absolutely no evidence that the dismissal of the juror was improper. I don't know what to make of it because too much of it's redacted. But it definitely sounds like Fanning was the guy they were pointing the finger at as the issue with the jury or a juror that was dismissed. The defendant's preposterous claims, one that Al Jackson has stated he had no specific evidence of, should be rejected outright. In sum, the defendant's motion should be denied. The defendant can show no irremediable prejudice to her right to a fair trial, nor has the evidence in good faith shown that the Commonwealth engaged in prosecutorial misconduct. Presumptive prejudice warrants dismissal to prevent repetition of misconduct. Ding, ding, ding. We do not want anything like has happened in this case to ever happen to another person in the Massachusetts area or around the country. Dismissal of the case is accordingly not appropriate. Further, where the defense's claims do not raise any substantial issues, the request for an evidentiary hearing should be denied. All right, everybody hit that like button. We're not going to do too much overtime today, but we are going to look at this motion to amend the trial order. Once everybody has hit the like button, we can continue on to that. Just let me know once you hit it. I have to see if lost evidence is turned over late and is exculpatory, can Karen Reed eventually sue Commonwealth for financial damages, i.e. legal cost, lost wages? For prosecutorial misconduct or law enforcement misconduct, yes, but not for late discovery usually. And just because she wins or just because the case gets dismissed doesn't mean she would automatically win a civil suit. Cosmo Nurse, I was on the jury of a trial a couple years ago. We were hung, but those of us that voted not guilty did it because the prosecution didn't prove beyond a reasonable doubt. I think that happens a lot when people actually understand what beyond a reasonable doubt means. Crispy TV, Brennan is a glowy. His presence equals fix is in. I don't know what that means. Hopefully it was nothing too disparaging. All right, let's get to it here. Motion to amend the court scheduling order dated February 10th, 2025. Now comes defendant Karen Reed. Respectfully moves the court to amend the scheduling order. As grounds, they state the following. On February 10th, the court issued a scheduling order which sets forth the hearing on defendant's motion to dismiss is set for either March 4th or March 5th. The defense was informed late yesterday afternoon, which was February 26, 2025, by Special Prosecutor Attorney Hank Brennan, that the Commonwealth has additional discovery to turn over for the defense, specifically alleged chain of custody reports relating to the Sallyport videos. This is after Brennan has already told them, you guys have everything. Today, February 27th, Mr. Brennan confirmed that he expects to provide those reports by tomorrow, February 28th, which is today, Friday. During his same phone call today, he further informed counsel that the Commonwealth will be producing Sallyport videos on February 28th. 3+ years after this happened and after this was recorded, and we know it was all purged after 30 days. So they have been in possession, custody, or control of this video for 3 years. So they're not getting it till Monday morning, which now we're into March. I think it's the 3rd is Monday. It is unclear whether the videos to be produced will be duplicative of what has already been produced or whether there will be new material. And that would make me think that Brennan hasn't seen them, because if it was going to be the same stuff, Brennan probably would have told him that. If it was going to be new material, Brennan probably would have told him that. I don't know. New chain of custody reports, which the defense does not have as of the date and time of this filing, will directly impact the motion to dismiss and cause the defense to modify its motion. In light of this new information, therefore, the motion to dismiss is not yet complete. There is no way Judge Cannoni can deny this motion. because this delay was 100% directly caused by the Commonwealth. So you cannot punish the defendant for something that was caused by the Commonwealth. The defendant got their motion in on time, would have been ready for that hearing. The Commonwealth got their response in. So everybody's ready for that hearing, except for the fact that the point of waiting till this date, they pick a date. We do these scheduling orders on purpose. They picked a date after the close of discovery on purpose so that this issue wouldn't happen. And yet here the Commonwealth goes doing it again. What do you think the judge in Baldwin's case would say? The Sallyport videos in the Commonwealth's possession that have been described as having been stored on the department's video file system. This new information will undoubtedly impact our written submissions and oral argument. These videos, according to the Commonwealth, are not expected to be turned over to the defense until March 3rd. Considering the above, the defense expects to file a supplemental addendum to our motion to dismiss, but this obviously cannot be done until we receive the outstanding discovery. As such, we are requesting a continuance of the hearing on the motion to dismiss so that we can analyze the additional information, confer about our expert, and file an addendum to the motion to dismiss. The defendant respectfully requests that the hearing on the motion to dismiss be moved to some date after the production of this information, but no earlier than the week of March 17th, particularly given the number of other critical deadlines that we are working to meet next week, which include satisfying all of our reciprocal discovery obligations, filing all motions in limine, and attending 4 separate hearings in relation to this case, 3 before this court and 1 in federal court. Failure to allow Ms. Reed sufficient time to appropriately address and brief these constitutional issues with information contained in outstanding discovery from the Commonwealth that directly relate to the issue underpinning the motion to dismiss would violate our constitutional right to due process and a fair trial. 100% agree. Now, I don't know if the judge is going to push it all the way out to March 17th, but she should definitely continue it and give him time. Got to give them time. This is our job as lawyers. We need to read. We need to breathe. We need to think about. We need to consider. We need to analyze. We need to form arguments. We need to do research. We can't just do stuff in 5 seconds. Like you can't just read something and comment on it. Maybe you can on YouTube, right? Like I can read something and comment on it, but if you're going before a judge and you're protecting the record of a case where somebody's life is on the line, you need to take more time to research, analyze, put things together, prepare your argument. And now with these delays, again, completely because of the Commonwealth and their delay in providing something that they should have had for 3 years, it's really frustrating. And I get it why people are pissed. I get it. I was on a jury and we ended up finding the person not guilty, but because there was a reasonable doubt, not because we thought he was innocent. Well, not guilty is not just innocent. Not guilty is not proven or innocent. Both. Didn't Brendan state in open court he wouldn't talk to the defendant on the phone anymore? He called to talk to them. I think he did say that. It's a great catch, Josh. That is a great catch. Thank you to everybody that gifted memberships during this video. We kept it to an hour. How about that? It's been a while since we've been able to keep a video to an hour, but there we are. And this just ain't how it's supposed to go. This is not how it's supposed to be done. This is not how investigations are supposed to be done. This isn't how processes and procedures are supposed to be done. This is not how discovery is supposed to be turned over. I can't wait to see what's in the chain of custody. Who did what, when, where, how, and why? And how can you prove it? I mean, there could be so much in the chain of custody, if it's even what we think it is. What if it has nothing to do with the videos or the red Solo cups or anything like this? Thank you, Azam. All right, that's all we got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.